Hi Karan, are you audible? Let's do a test.
Hi Nitya, you're audible.
Yeah, okay.
Hi Nitya, you're audible
Yeah,
clearly.
okay. Joseph, take it live. We'll wait for 2 minutes.
Yeah.
Welcome to Solve It Ask Me Anything session. Today we have joined with the two experts. Okay. Today we have our two experts, Rishi, the CEO of Zolvit. He has been the forefront of simplifying the legal tax and compliance services across the globe. And we have Karan, our intellectual property lawyer, who has been guiding the startups and small businesses through the trademark, patent, and IP challenges. So, Karan, I had a question for you to break the ice. Let's say two businesses launching the exact same product. One secures an airtight intellectual property, while other focuses entirely on killer brand strategy. How would you approach, and what is that a client should follow?
See Nitya, again, whenever you are starting a business, yes, you need to have a brand strategy in a way wherein you are actually planning the entire brand launch in a stage wise manner. So whenever you're launching, considering there's a FFCG kind of a business that you are having, so again when you're launching you need to see when you're launching the right brand at the right time for the right audience. So it's a phase wise manner. It's not always about going ahead and protecting it, but there's a basic strategy about when you are applying the brand names, and what is the right brand name that a person will actually recognize them, customers will recognize themselves with. So that branding strategy and protecting your IP goes hand in hand. It's not something branding strategy is done by one team and trademark protection or IP protection is by separate. Both goes hand in hand, wherein you have to apply for those kind of IPs or those trademarks or those kind of designs which people will recognize with, and that will actually lead to obviously which will have an effect upon the revenue and scaling up of a business.
Okay, so however airtight the product is and a killer strategy, still it how does it pan out for a business? Rishi, how do you think about it? Like we have a very competitive market out.
So I think it's like brushing your teeth in the morning. I think it's not that it increases your lifespan, but it definitely is necessary as a best practice for every business or every individual, that is, for basic hygiene. Right? So can you live without brushing your teeth? Yes, theoretically you can, but is it good for you? Definitely not. So I think I would say today, in today's world, especially where every business is known by its brand, protecting your IP is literally as essential as brushing your teeth for a human being.
Okay. So, Karan, what are the basics that you would want an any business owner to do? Let's say a couple of days ago, when we saw BMW, Bombay Motor Works, and actually BMW. So, how do we understand like a brand which someone feel like it's a heroic moment for people, or they love it, or they are very much fantasizing about? They want it just like it. How do you think, Karan, they should rule it out, or what is the goal that that is the step one? How do you think it should be it?
See, the first step when you are applying a trademark is to check. As simple as that. It is again two-parted. Firstly, whenever you are coming with a brand, firstly, yes, you need to come up with a brand for which you feel that people will easily remember. Many people like end up applying a very long brand name, or which is a very complex brand name to even pronounce. Nobody will remember that. Nobody will remember that. Nobody will recognize with it. So you need to come up with some unique, catchy brand name. So do that whenever applying. Come up with something catchy, nothing which is very generic or very common in use. Or like you should not be applying for, okay, a big bicycle or flying car or something which is very generic in sense. So always come up with something catchy. And once you have come up with a few brand names, get a proper check done. That is one of the major mistake which I feel many businesses, you should know, not go with emotions. Because currently I would say in the Indian atmosphere, there are more than a crore application that has been filed with the registry. So it's very important that a person do a proper check to see if their trademark is even available and what are the risk scenarios. So get that proper check before even going ahead and finalizing a trademark.
Oh, that's great. Rishi, what do you suggest as a startup? The young Gen Zs, the millennials out there, who are not much of a traditional setup. What would you say? Because they use a lot of tools, Power Gen, AI, a lot of support. But how do you think they should use active and the smart assessment has to be done like a business owner?
So I think the first thing is just doing a Google search, right, to see there's something with a similar name. That is enough for a startup. If you enter your name, for example, your name is say Vakil Search, and there's already a brand called Vakil Search. Logically, don't do the same. Give the same name because it will hurt you. But if you on Google, if you don't see that name appearing, then you should contact an expert, right, and see if they can do a search. And typically, if your name is not appearing on Google, good chance that you will get the name. Uh, if there is some similarity, then the expert may advise you to do a logo combined with the name. So it's called a logo composite mark. So some of that the expert can guide you on how to improve your chances. But basic sanity check is just do a Google search and then talk to an expert. Over to you, Nitya.
Yeah. So, Karan, there are a lot of complex terms when it comes to trademark, right? So, it's not just the word. It's so some people secure the word, but it falls back on color combinations. What are very unique to a detailed manner when in terms of logo of a company or a name? What are the unique things that you could not miss it out? And as a lawyer, what do you see that every application has missed this? It's a common mistake that every applicant has done so far. What is that you get, like, this is the most annoying thing, but it is the common mistake? What do you think it is, and what do you suggest a business owner should avoid at first place in those mistakes?
Okay, okay. So Nitya, again, there are two to three things that I've seen very commonly that is happening. So I would reiterate one point that I already mentioned around is when you are applying for a brand name, usually people feel that so that people can relate, apply for a very generic term. So people end up applying with a very generic term, and trademark laws have been constructed in such a way which bars any generic or very common term to be allowed as a trademark. So it's same like you cannot apply for a trademark for apple for selling of an apple fruit. So you cannot do that. So that's something that people should recognize, that you can add that whatever generic aspect, whatever is the exact product, that can be one of the suffixes to your trademark, but that cannot, the exact generic word cannot be your main trademark. That is one thing. Second aspect that I always suggest people is, if whenever you are applying trademark, they at one point of time they would have already started using the trademark. So, like for example, you are coming today to me and applying current key. Yes, I want to apply the trademark today, but they might be actually using the trademark for last 1 year or 2 years at a very low level. They might be going on a global level now, but at a low scale level, they might be doing it for 1 year, 2 years. At that point of time, that is an advantage for you. That is an advantage for a startup or a company wherein you can showcase the trademark registry that you have been doing this entire business for past 2 years, and that gives you a leverage at a later stage of an examination. So I think these are two things among many things. These are two basic things that a person should take care of when applying initially.
Okay, so when it's just the phase of putting an application for any business, so there is a very huge confusion where every business owner has this TM symbol and the transition to the TM to R symbol. How long does it take, and what is it that adds value to a business owner from TM to R? And how do you think, Rishi, that is a huge impact? Like when we say you are applied to a TM, we get a status, right? That's a status. How do you think a IP lawyer could help us, the transition phase? How do you think the portfolio would matter?
Understood. So I think there is a lot of difference between TM and R. TM symbol allows you to at least start positioning that your brand is protected. So after that, nobody else can apply for the same name. You will have the precedence in terms of having applied before. But if somebody can show that they actually they had started using it earlier, they can challenge your mark later. It becomes very difficult for sure, but there are two kinds of regimes in the world: first to file and first to start using. So the a lot of power goes to just filing. So my advice to everybody would be: if you have a unique name, file immediately. Having said that, the difference between TM and R is a registered trademark. That's
Yes.
when you have gone through the formalities and the registry has approved your trademark as being genuinely unique. There are some advantages to this also, right? So you can, for example, if you're on Amazon, seller on Amazon, you cannot sell abroad in US markets unless you have, or other markets, unless you've got a trademark registered. A trademark application is not enough. Also, if you're going to getting into agreements with companies abroad, at least especially in Europe, many of them prefer if you have a registered trademark because it shows that due diligence on your trademark is over and it's a genuine name. Right? So it's a sign that your business is stronger. So those are the advantages. So, Mike, in a summary, first step is apply immediately if you have not already applied, and if your mark is yet to be registered, then it's you get some advantages once it's registered.
So every business should register the first step, and the TM should be happening.
I think all the people who are here on this thread know that,
Yes.
which is why they are here. The question really they might have is, how do I register? Right? What are the steps? What are the risks? What are the rewards?
Yeah. So, Rishi, given the rise of the counterfeit products and copycats around, the strategy that leverages around the notion of the trademark to protect the brand and they maintain, what are the steps, like how as Wakil Search or how as Solvit, we stand for the, small businesses and for the enterprises? How do we say as a notion to start, who are already a well players but not registered as a trademark, and even the copycats, how to stand out, what is the process, how to get it an easy access to be, what are the steps to register?
So it's very simple. First, you need to do a quick Google search yourself, then go to an expert. Let the expert do a search, then apply for the trademark. Typically, within 24 hours, uh, anybody can apply today within 24 to 48 hours, but some companies can do it even faster. Right? In 4 to 5 hours, you can get it done. Then the trademark, once it's applied, typically in some time, once the payment is processed, once the government has done some basic scrutiny, within a day or two, you get a trademark application certificate itself that the application is done. Then it takes some time for the registration to happen, which could be as little as a few months if you expedite it. So there is a process to even expedite it. You can pay an additional government fee and expedite the hearing, expedite the scrutiny. That's, I think, 20 to 25,000 rupees of government fees to be paid over and above after the application is done. If you don't want to expedite it, then it takes some time. Right now, there's a lag at the registry, so it could take 6 to 9 months for the trademark. But if you expedite it, it can happen in a few months also.
Right. Karan, what should be an understanding about a trademark class to a business owner? How important is it to understand about a trademark class, as in, understanding for a trademark, or how beneficial is it for a business owner to understand?
Correct. Yeah. So again, when we talk about classes, again, and just give a brief background. Internationally, all businesses have been categorized into 45 different categories as per NICE classification. So class 1 to 34 talks about different kind of goods, or any and all businesses which have goods in it. 35 to 45 deals with services. So the major aspect, again, whenever anybody is getting into business, is to choose the right class to protect their entire business under the right business category, because many times there are many products which are overlapping, to which people usually get confused, and if you end up applying in a wrong classification, the entire production is useless because you're not selling that product altogether. So like I will give an example. So like for example, class 5 is for selling of medicines, and class 10 is for selling of medical based equipments. So there is a very common issue wherein people end up applying for medical based equipments in class 5, and now it is not protecting them at all. So after registration also the entire trademark becomes useless. So that's where you need to get, whenever you are doing, again, do your personal due diligence, and after that, when you're talking to an expert, get it clarified ki what is the right class that you are following. Also, one aspect people should understand, when you are applying your brand name, it's not about applying it in one class or finding that perfect class. There are many companies who apply a trademark in 10, 20, 30 different classes. There are two basic logic for that. One basis is कि, okay, they have goods which are falling in multiple classes. They have some basic, like a FMCG company, they will have various different kind of food based products. They will easily fall in roughly around 4 to 5 different classes, depending upon the nature and the composition of the product. But also there are companies who venture into the aspect कि, okay, right now they have a growth strategy. कि right now I'm here and after 5 years I'm going to be in 10 different industries. So you need to plan your IP and IP registrations today and apply for them in all those 10, 20 different categories where you vision कि after 10 years or 5 years there you will be. So that visioning has to be done and applied accordingly in advance rather than later.
But Rishi, what do you think? Would a business would understand the hard, complex jargon? Is there any way that yes, a person should know, understand right fit of the product? How about the jargons? How to across him?
No, there's no need to understand the jargon, no? So I can go to a doctor. I know that I need to take a blood test. I don't need to know why the blood test is necessary for me. That's a doctor's job. So
Yeah.
similarly, for a business, you need to apply for a trademark. It's necessary for your business. It takes some time. For a business owner, I would say don't try to understand the whole process end to end. You focus on the business. Right? And frankly, it's not a very complex process. It's a simple process, very straightforward, and it's necessary. So rather than that, I would say just do basic scrutiny yourself to see if there's nobody else on Google with the same name. And as long as that is there, you're in good shape. If you have multiple brands or you have a logo or if you have a slogan, you may decide, okay, my budget is only to protect one or two right now and protect more later. That's perfectly fine. So protect what is most important to your business first and then keep on adding more. But ultimately, when your business is about 4 5 years old, you should have a portfolio of at least 5 to 10 trademarks covering all aspects of your business because that's the only way you'll build a strong IP portfolio. IP doesn't stand come alone. Right?
Hmm.
IP comes as a group portfolio. You'll have trademark, you'll have a copyright for your website, you'll have a design protection for your product. You may have a patent if you have an invention. You may have, if you're into some very niche category, you may even go for a well-known trademark, which is a higher level of protection across all the classes. So IP comes as a family of solutions which every business needs. But the very first step for most businesses should be filing a trademark.
Yeah. We are getting some questions, so we'll just ask one by one. So just a second. We're just getting questions. Okay, first question is, can I trademark a business name that is already in use but in a different industry?
Okay,
Karan, you can go ahead.
sure. So again, considering yours, can I use a trademark name that is already in use but in a different industry? So considering again, right now I am in the business of, for example, into paints, but again now I am creating a business and I'm going into the business of chemicals, for example. Can I use the same brand name? Yes, you can use it, but again you have to make sure that the entity holding the IPs is same. So even for the chemicals and for the paints, the both entities, the trademark should be have to be applied in both the classes. So like for chemicals the class 1, for paints it is class 2. The both the trademarks should be held by the same entity, and you can apply for the same. But yes, the only aspect is you have to apply for separate trademarks for both different industries.
Okay. Can I sell homemade wine in Kerala and across India with a registered trademark?
So trademark is not the problem, but the problem is selling liquor has a complex set of regulations, right? So I think this is a very exciting problem. I have a personal interest in this, but quite apart from my personal preferences, selling alcohol, this gentleman or lady has to study the rules carefully. So we would maybe Nitya, you and the team can get the contact details and we can reach out later. But
Yes.
trademark is not the issue. You can, if the laws allow it, the liquor laws allow it, you can sell your trademark with registered trademark across India. But different states have different rules with regard to taxation and also sale of alcohol. For example, a state like Goa is very liberal, but a
Yes.
state like Tamil Nadu is quite strict. So a state like Delhi, until recently, was quite liberal. Now, of course, we know what's going on there. But it's all depending on the state. From state to state, it differs.
You get the next question. Can one apply for a trademark under more than one class in India?
Sure, Nitya. Again, when you apply for trademark, yes, you can apply for the same trademark in more than one class. Whenever you apply, there are two ways you can apply. Either you can file it as a multi-class trademark application, or you can file a trademark separately in each classes. So it's like in a single application, you can add all 45 classes and apply a single trademark. But yes, you can apply separately also. Normally, I always suggest people to apply the trademark separately, because again, if any of the objection comes, considering you have applied in 45 classes in a single trademark, if an objection is raised on the basis of one single class also, your trademark is getting stuck in all the remaining 44 classes. So it is normally suggest to apply separate trademark applications for each class.
Okay. Okay. A trademark registered in USA in the name of ABC. Can I register in the name or run a business in India with the same name?
Yeah, you can. You can. It's advisable that you, unless you really have to, you don't. If it's a well-known name, for example, if it's a company like Tesla, which may not be selling cars in India, it's advisable that you don't start selling cars in India under the name of Tesla, because you will face challenges tomorrow if Tesla decides to sell cars in India, right? And uh, they will get the benefit because they have been selling. See, ultimately, trademark protection is about genuineness and originality. So
Correct.
if there is a similar brand in a different country which is very well known selling the product in that country, then don't blatantly copy them. On the other hand, if it's a small, relatively unknown brand in that country and they have no entry into your country, then why not? You can do it.
Okay. So there is one more question. So why should a small business prioritize trademark registration and what risk do they face if they don't?
Okay. See, whenever you are starting a small business registration, yes, the most important aspect is to have a initial basic, get your GST and your basic compliances. But trademark is important. Reason being, in the way India is growing and is expanding on a business is crazy right now. And at that scale, every day a new business is coming who might be coming up with something similar, or a similar kind of a brand name, or a similar kind of a brand idea, or a business idea. So the whole point is you cannot delay registering your IP, because you don't know the next minute somebody else might be having something similar, they apply before you, and now you have to rethink about the entire business strategy, branding strategy again altogether. So that's where, even though if you are small, you plan to scale it up and big, trademark is important to prevent irrelevant legal hassles or legal disputes at any point of time.
How much a patent research analyst can earn in India?
I know, I saw that question as well. It really depends. I know that it's a question from LinkedIn. It really depends.
Yeah.
It can be as low as 10 to 15,000, and if it's per month, and it could be 4, 5 times of that if you're, or 10 times of that if you're really, really special in a unique area. So if you're in pharma patents and you have a lot of experience in pharma patents, a pharma company may even pay you 10 times of that. So it really depends. But the lady, I wish her the best, Lipsa.
Yeah. Okay. How does having a trademark impact a business ability to scale or enter new markets?
No. Okay, I
So
will respond on this.
please go ahead.
Sure. See, whenever you are, once you have a basic trademark, currently, if you see the current scenario, a good number of sellers or businesses in India are going with e-commerce. They are starting their business on Amazon, on Flipkart, on Meesho, on Udan, and many different platforms that are there. So the whole idea is once you have a trademark registration, you become kind of a verified seller over there. That you are a person, you have a registered brand name. And once you have that registered brand name, you are given a prevalence. Your product will not be titled as generic. So whenever on all these platforms you are titled, your brand name is titled as generic. Once you have a register, you have a brand name, you have a trademark applied for it. Then you have a trademark. So that gives you an edge in scaling up, in doing different activity, and obviously when you're looking to scale up, it will protect any and all kind of infringers. It will safeguard you. You will reduce your chances of counterfeit because it's a very easy scenario. They see a brand which is growing on Amazon. It's a very common day scenario, or Flipkart. They see a brand that is growing, which is having a huge sale or having a huge hits. People will see, they will try to imitate the same product and start selling something else out of it. So to prevent those scenarios, if you have a trademark, you can file complaints with Amazon or Flipkart because everybody have their own grievance portals. If required, we can send legal notices to all these infringers for violating or copying, or else we can file an opposition before the trademark registry. And at the last resort, we can even initiate litigation in a district court or in a high court. So the whole point is it's once you have a trademark, it prevents you and legally and helps you scaling it up in a stepwise manner.
What legal protections do I have if someone uses a similar brand name?
Legal protections of,
Yeah.
so you can basically, I think Karan mentioned it, so I'll just repeat what he said.
Yeah.
If there's a process called infringement, so you should keep on checking, and you should ask your expert or your lawyer to keep on checking for you if anyone has filed for a similar name as yours. If there's any similar trademark to yours, you should immediately file for an infringement. Send a legal notice and file for infringement. Uh, Basically, you should take action with the registry for infringement. And then if they don't come to a settlement with you, you can even go for a litigation actually. You can even take a legal action against the party in a court of law to get the other party to stop using that name. So you can send what is called a cease and desist notice. Again, I won't go into jargons, but I'll
Yeah.
keep it simple. Right? You can send a legal notice to the other side asking them to stop using the trademark. You can come to a settlement. If they don't settle, you can even take legal action by filing a court case against them.
Okay. We have few LinkedIn questions here. Okay. Can you give a famous trademark case and an example for us, a business, and what did they do wrong?
So, a very famous case is Oreo. So, in fact, most people don't know that Oreo did not invent the sandwich biscuit cookie concept. It was a company called Hydrox which actually invented the sandwich biscuit cookie, and they were not smart enough to commercialize their IP. I would not say smart enough. It just happened. Sometimes businesses go through some bad luck. So as bad luck would have it, they did not commercialize their IP fast enough. What happened was Oreo took the same idea and did a much better job of marketing it. Today, 100 years later, or several decades, I think it's 100 years plus.
Yeah.
Yes.
Oreo is actually is a globally known brand. Everybody in most countries understands what Oreo is, and on a regular basis they also eat the product. It's a very tasty product. But Hydrox, which despite being the pioneer, today is nowhere. Right? There's
Yes.
so many companies in the tech world which were big brands, but they did not commercialize their IP fast enough. So somebody else captured the domain and got the best reputation in the domain simply by capturing the IP faster. So that's a very sad situation if your business has the idea first but doesn't capitalize on the opportunity.
Yes. Okay. So we have another question. What if a business already owns a domain name and social media handles? Is registered a trademark still necessary? Registering a trademark still necessary? Yes.
Yes, it is. It is. If you already, irrespective, you have a domain name and social media handles, that does not prove your legal ownership of that trademark. So when you apply a trademark, you have a legal certificate to prove that you have a registered trademark, and you can use that in any kind of disputes.
Okay. And Karan, I wanted to ask you when came across this question, domain name, apart from trademark infringement, there are a lot of other aspects to the IP and trademark, like trademark dress and other stuff, which people are not aware, loud out. So, like Jack Daniels, Coca Cola bottle, maybe a parachute bottle, these things, when they come up, how do you think it is an important aspect to, an entire trademark journey, and how much value does it create as an asset for a business? Apart from all those infringements, how are these things domain name disputes? These are all like, regular. Like how regular is it, and how can they avoid, like, how much often do you see these things also?
Correct. See, I would say that is a two-parted question. Firstly,
Yeah.
on such kind of disputes that is happening on different kind of versions of IP or the branding that people try to copy, it is very much evident these days. It's just not about getting the right trademark. So, because when you talk about trademark, there are various different versions of it. Trademark is just not the brand name or a composite logo. So when you talk about trademark, there are, I would say, 7 to 8 different types of trademark. So like one is a basic, again, a basic word mark, which is TATA, for example, Tata. Then again there is the logo. Then there is a logo plus the word mark together, that is called as composite logo trademark. Then there is slogans that are there. Then there is something called as 3D trademarks. So wherein you put up the pictures of the entire product which you feel that is your brand, or that is how your product look is the brand, you protect that as a 3D trademark together. Then even there is something called, again, those we call these as unconventional trademarks that I'm going to name now. So like even 3D trademark is unconventional. Then there is something called as motion trademark. So it's like how we have that Nokia hands coming together, motion together, they're coming together. Even that motion can be trademark, that's called a motion trademark. Then there is sound trademark is there, then the color trademark. The point is, there's a huge list, the kind of trademarks that how you, what you can apply and do. It's about when a company is applying, you need to analyze your business as to what is your unique features about your brand and product. If you have created a very unique shape of a bottle, for example, and you feel that is your branding, that is part of a branding strategy altogether, you need to apply for the shape of the bottle, protect that as a trademark and even as a design registration also, if you feel that is something unique. If you feel that any kind of a sound is, you are trying to make that as your recognizing feature, like how Ola, as a cab comes, there's a door opening sound that comes from the Ola app or something. So that sound, or if you feel that there is a any kind of sound that you feel that you want people to recognize you with, you apply that as a sound trademark. So you need to analyze ki what are the unique features or how people are going to recognize you, and that then you apply that as a trademark.
Okay. Just go to- Can we have a patent or copyright for an idea in India? Is that possible if it is very unique?
Okay. Okay, I'll take that. So yes, again, it depends upon the kind of idea, what idea you have. So if you have created a kind of a machine, or if you have created a kind of a product which is solving a which is solving a problem which has not been solved before, or is solving a problem in a much better format than the current solutions, you can apply for a patent for the same. If you are having a solution also, or a chemical, or you have a unique kind of a hair oil, something which is having a unique effect, or if you are like creating a unique kind of a process for doing some to doing something, or you're creating a very unique software based hardware you have created, and any IT or tech based software that you have created, all those things you can patent it. Again, even you can apply for copyrights if you have A unique business idea. So because many times people say, "Ki, I have a unique business idea, can I apply for a patent for the same?" So it's normally not patentable something until unless you have a product around on it. If you have a very unique business idea, the basic processes apply as a copyright, because under copyright there's something called as concept note. So as a concept, if you have a very unique concept, you can write down and create an entire concept as a document and apply for that as a copyright, and you can protect the same.
Okay. Concept note. New thing unlocked. So, another question. Can a tune like Aircel still be protected even though the business is no longer active? Rishi, your thoughts?
No, you so the business is no longer active, but the trademark belongs to the owner, proprietor. Then he can still protect it because it's in his name or in the individual's name. If the trademark is in the business's name, but the business no longer exists, if it's struck off. So again, what is no longer active? If the company is still active and it's filing its returns with the ROC every year, even if the business is no longer there, right? Uh, Technically, it can still claim that even if you know they are still running the business, although they're not selling to customers at a scale like they were doing earlier, they can still claim and demand that the trademark stays with them. Right? So you will see today Maruti has a car called 800, or used to have a car called 800. Today, even
Yes.
if it doesn't sell the car called 800, but the company is still running. Right? It may not be selling that product anymore, but it can still demand that nobody else can start and sell a car called 800, because it'll keep renewing the trademark every 10 years. So the business being active is not the criteria. If the business no longer exists itself, so the business is struck off by the ROC, and it's a defunct business, like maybe for example Dunlop tires used to be there in the past, but it doesn't no longer, the business to my knowledge no longer exists.
Okay.
Then theoretically, yes, you could try and get a name Dunlop for yourself. But Aircell's tune, if the business still exists, or even if the business is not selling telecom products, but the business is still alive on paper, then it's very difficult to protect it. In fact, I would strongly recommend that you don't try to copy that tune. Come up with an original tune. And if it's already in the public memory associated with Aircel, you don't want your business to be associated with, especially if the brand is not still thriving in the market. Why would
Yeah.
you want to be associated with a brand which had a unfortunate, history? You would want to be associated with a brand which has a very powerful history. So, and those brands will not give you their tune anyway. So, my advice is to the creators here is to create something unique.
Correct. Does IP have value for IPO listing?
100%. If I'm not mistaken, companies like Nike, uh, a substantial percentage of their value today only comes from the swish, or swoosh, however you say it. So that the tick mark which IP which Nike has is a substantial chunk of its total valuation. Forget the revenues. So even Apple, the logo with the Apple button
Yeah.
is a substantial part of Apple's overall valuation, which is 1 trillion or $1.5 trillion, right? So that that logo itself is worth hundreds of billions of dollars. So that's how big, which is the GDP of say Singapore. That's the value of Apple's logo. That is how powerful it can be. So in fact, Swiggy's trademark, Vakil Search had the good fortune of protecting Swiggy's trademark. So we are the owners of the trademark. So we can't share what it is worth, but it
Yeah.
is worth a lot.
Yes. Can
Yes.
I use
Yes.
the
You can use a logo of a company. Again, you can technically, unless the owner of Blockbuster owns the trademark. They may own it. They may not have given them, it may not be in the company, it may be in the owner's name. And if the owner owns it, he may keep renewing it, even if he doesn't do business. Now, do you have a good case? Yes, you have a good case because the brand is no longer used, right? So you can always challenge saying the mark is no longer in use, which is why I'm using it. But I would strongly recommend against doing that. If you go to the trademark registry and the trademark is not been renewed, so the trademark is defunct or dormant, then you can go ahead. Otherwise, please refrain.
Yeah, there is one LinkedIn question. How reliable are AI powered trademark search algorithms in identifying potential conflicts?
Quite reliable. Quite
And
reliable.
they
Very
are
reliable, in fact.
they are grounds for litigation or invalidation of an existing mark.
They are very valuable.
Correct. Even because even we have seen in a few litigation cases that happened before, even in the Delhi High Court, wherein the courts have acknowledged the importance of AI-based results also. So if there is an analysis that has been made through using of an AI, they have acknowledged that. And currently, India is going at a stage wherein even the courts are analyzing and acknowledging the basic analysis being made over there. So yes, if the softwares are doing that, it is very much acceptable and acknowledged.
Yeah. So I'll just wrap up because it's a quick. Okay, Rishi, this question was for you, I think. As a business owner, which IP was your fanboy moment?
Uh, I think legal is now simple because it represented what we did as a business and what we were at least aspiring to do. Legal is a very complex field, so beyond the point, it's very hard to make it simple. But we keep trying, and we keep trying to get better every day. So we are not perfect, but we are trying hard. So that would be that in my mind would be the
Fanboy.
best IP that we have protected.
Yeah. Okay, so Karan, how would you conclude like how the trademark is like, you have seen it's evolving and the patterns. What is your strong suggestion for the, not just the business owner, individual freelancers? How do they, protect? How should be they aware, just about their IP assets, the management? There are open gates for Meta, NFT. There is lot of very complex things which are getting open out in legal zone. How do you conclude that?
See, again, for any business person, with the current way of how IP is being valued, as even Rishikesh was mentioning, IP in foreign countries, like they are valued at roughly around 66% of their business. Entire business valuation is derived from their IP, from the patents that they have filed, from the copyrights, from the designs that they have. So we need to understand that we are, as a company, how when you are growing, you need to talk to experts whenever you're starting a business. You need to talk to people, you need to talk to an IP lawyer to conduct a basic IP due diligence for your business. That is of a crucial aspect because it's a very it's a gap, I would say, still which we are trying every day to educate, and people are also reading through. Trademark is not everything. Trademark is the first step, very right. But after trademark, there are many other aspects as copyright, design, patents, geographical indications, Plant and Varieties Act. There are many kind of different IPs are there. So you need to have a detailed discussion as a point of revenue and to showcase your valuation, what all IPs that you have done and how that is adding to your business. So that's something that I would say any business who's starting to have one detailed discussion to analyze this aspect about their business as to what all things that they need to protect, what time is the right time to need to protect the IPs, and what are the things that they need to do on a first step and second step and third step.
Okay, I think Karan, one last question. Will my brand name be opposed by someone if I'm running my business in that brand name for 10 plus years?
So again, when you talk about opposition, if your brand name you have been running for last 10 years, yes, your brand name can be not opposed. I would not use the word opposed, considering you have a brand name which got registered also. After registration, there's something called as rectification proceedings. So that can be initiated against you even after your trademark is registered and after 10, 20, 50 years, 100 years also. And even you, irrespective of if you have not applied your trademark, yes, at that point of time, a proceedings can be initiated in a district court or something, because since you do not have a trademark and you're not applied for it, but you are using that trademark, the right forum for initiating the proceedings will be a district court or a high court. But yes, legal action can be taken.
Okay. Rishi, your thoughts, how is, like, we wanted to conclude this session, so we wanted to know what do you want to say out there loud to the entrepreneurs, freelancers who are just
First of
hiring.
all, don't be scared about getting a trademark. For many people, it's a very scary thought, or they get intimidated that I have to do it's a trademark. It's just a basic first step, and once you do it, you'll realize it's very simple. Number two, trademark is the beginning of a journey. So remember that whatever you're doing as a business, you're doing something unique. So all aspects of the business, try to slowly protect it over time. Trademark, then your website copyright, then your unique ideas, a design or a patent. So look at IP as a portfolio of things which you need to do to protect your business. And why should you do it? Because over time, when you're building a business, the only thing which will get you value when you decide to sell the business is the IP, the uniqueness of the business, and of course your customer base. Those are the two things, right? Otherwise, what is there in a business? Not the stock, not the inventory, not the machinery that can get sold at scrap value. This is what will get sold at real value, right? So remember to protect that and focus on trying to build a different story around your brand. So that will also, like Karan was saying, a sound trademark is such a unique idea because it gets you that differentiation from everybody else out there. So focus on how you can differentiate so that you're known in the market rather than lost in the market.
Yes. Thank you so much, Rishi.
Thank you
Thank
so
you,
much.
Karan. It was really great. And
Pleasure.
yeah, thank you so much. We
And I
would
think
come back.
there were several other questions.
Yeah.
So maybe if they reach out to us, we can reply to them as well. I'm
Yes. So
sorry for
that
those
is
who
good.
couldn't answer,
Yeah.
but we will be in touch.
Yeah, we have sent a form there, so you can, put down your queries, and it would be great. We would reach back to you. So the form is in the comments of YouTube and everywhere. The live is being streamed. So thank
Thank
you.
you. Thank you,
Thank
sir. Thank you, everybody. Real pleasure.
you.
Thank you. Thank you.